The Chevron Doctrine is gone. The handcuffs are now on the federal agencies instead of the other way around. And Scotus is wrapping up the spring session. We got a lot of stuff going on with two-way litigation. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, the Supreme Court spring session is now over. Today is the last day to wrap up some things because a lot has been happening. A lot happened today. We have brought back CRPA President Chuck Michel to walk us through it. Chuck, thanks for being on with us today.
Always a pleasure, guys. Thanks for having me.
Absolutely. And guys, before we get into this today, please, it is working. Be sure to like, share, and subscribe to these videos. It's a way that you can directly contribute to the fight in California with the litigation and the legislative effort. So please be sure to do that as we continue to put this stuff out throughout the end of the year. So Chuck, I guess, we've seen a lot of things happening. I want to focus on something that happened at the end of last week first before we get into the things that have happened today. We saw the Loper Bright Enterprises, which wasn't exactly a Second Amendment case, but has a lot of ramifications in the Second Amendment litigation world, where the Chevron deference was basically shot down. Can you go ahead and tell us exactly what the Chevron deference was, how it's been affecting the firearms community, and why it was so important for it to get taken away like it was?
Well, Chevron deference was a doctrine, a legal doctrine that basically said administrative agencies, executive agencies like the Environmental Protection Agency or the ATF or any number of other agencies, tax agencies, any number of other federal agencies, when interpreting statutes or their own regulations, courts were supposed to presume that they were experts and that whatever their interpretation of what a statute meant was entitled to deference by the court. The court was supposed to say, well, you're the agency, you know better than I do. And that's always been a false construct. And that resulted in things like the ATF declaring bump stocks to be machine guns, or the Environmental Protection Agency declaring some puddle, to be a protected wetland, because they want to. The government agencies always interpret everything to expand their power, expand their authority. In the Loper Bright case, it was a marine agency, a marine regulatory agency that was charging a company to monitor. I think it was a boating company to like $700 a day to monitor their businesses. And there was nothing in the statute that authorized the agency to do that. They just kind of made it up. And that's what agencies, administrative agencies, executive agencies, government agencies do. They will always presume that they have the power to do something. And if anybody challenges it, they say, well, here's where the law says, and we've interpreted this regulation or this law to give us the power to do it. Whereas before, the courts had to say, well, they're the ones that are entitled to deference. We have to defer to those agencies and their opinions and give them credit as if they're experts and they know more than we do. Now it's a level playing field. Now the agency does not get deference, which is smart because the agencies are not objective. They will never interpret a statute to limit their power. And so this was long overdue. And a lot of the overreach by administrative agencies can now be pulled back. And if there's some reason to give an agency authority to do something that's not in a regulation or a statute already clearly, then Congress should pass a law to give them that agency. But agencies should not be self-empowering, and that's what the Chevron deference doctrine did.
Well, yeah, there's and the ATF seems to be the big three-letter agency that's brought up here. We've seen a lot of bans that the ATF has been imposing. And guys, this is going to be interesting to watch after this Supreme Court decision. If you want us to keep an eye on the ATF, it's not something we've typically covered on this channel. Leave a comment in the comment section below letting us know whether you want us to cover that stuff or not. It's going to be really interesting to see how this plays out with these these agencies, and there's always ways that California shapes the rest of the nation and the federal government shapes California. What are the ramifications from this Supreme Court decision that you see affecting California?
Well, there's already some of the big law firms are already creating regulatory litigation departments to challenge a lot of the regulations, not just ATF, but all the administrative agencies, to challenge some of the regulatory interpretations that these agencies have made. So there's going to be, and this is going to be huge corporations with, millions of dollars for their litigation budgets, paying big law firms, the biggest law firms with hundreds or thousands of lawyers to challenge some of these regulations, which is why one of the dissents, I think it was Sotomayor, was so, clutching her pearls over how much the federal government was going to have to how much work the federal government was going to have to do to defend the regulatory interpretations that are on the books right now. But the federal government made its own bed. These agencies made this bed by being selfish and being self-promoting and self-empowering. So it's about time that they had their wings clipped. Now, in California, all these regulations apply nationally. So any of those regulations that are being applied in California can be challenged. As far as guns go, by the way, CRPA is always keeping an eye on ATF and what ATF does, and we submit amicus briefs. For example, in the Cargill case, CRPA submitted an amicus brief there, pointing out that what the government was trying to do was blur the line between full auto and semi-auto so that they could condemn semi-automatics as if they were fully automatic machine guns. So we're always watching that, and we will be continuing to watch that. And as ATF continues perhaps to try to expand its authority by interpreting regulations differently, CRPA and Second Amendment Law Center will be involved in pushing back and fighting against that.
Well, I understand
along with the other gun rights groups.
Right. I understand this is a little bit more in the administrative part of the law, but the way that you're talking about it is actually, for me, kind of reminiscent of the Bruen decision. Would you say that the impact here is great, sort of like the Bruen decision was, eliminating the Chevron Doctrine?
I don't think well, that's tough to scale those. I don't know that it's quite as significant as Bruen was. Bruen really set up a new test for determining whether or not a law violated the Second Amendment. This is a restriction. This is not a second. The Chevron Doctrine case is not a Second Amendment case. It's an administrative law case, and it's big. It's probably the biggest thing that's happened in administrative law in 40 years. But it's hard to say which one is more significant.
But impactful nonetheless. I get. Let's talk about some other things that the Supreme Court has done. We have been on Scotus watch. We've been saying that for the last couple of months here. A couple of cases that we were really focusing on were coming out of Illinois. This being the last day, did we see anything happen with those cases out of Illinois?
Absolutely. Remember, yesterday was the last day that the court issued decisions on cases that had been argued and briefed, and oral argument took place, and the Supreme Court took them under submission, and then they write their opinion and they publish their opinions. And so last week they put out a few, and yesterday they put out the last couple of cases for this session of the Supreme Court. And the biggest one was the Trump immunity, it's not even Trump, it's presidential immunity decision, which you've probably seen on the news. Okay, so today, cases that had not been yet accepted for review. Remember, the Supreme Court can take a case, but it doesn't have to. And there had been a number of cases that had asked the Supreme Court to grant certiorari. It's the review of a lower court decision. And the Supreme Court had held those, basically all the Second Amendment cases and a bunch of others, until the last day of the session, which is today. So all those pending requests for the Supreme Court to grant cert review a lower court decision and then make a different decision were cleaned up today. They do them every week, and all these Second Amendment cases and a number of other cases were put off until today, the last day of the session. So when the Supreme Court decides what to do with a case, they can grant cert, in which case they're going to do a full merits review of the lower court decision. There's going to be briefs filed, there's going to be amicus briefs filed, there's going to be oral argument, and then the Supreme Court's going to take it under submission, and then they're going to issue an opinion. Now, if they had granted cert in any of these cases, then those cases would be briefed next Supreme Court session, which begins the first Monday in October of this year. So that will be the next session. This session, the 23-24 session, is now closed. So the 24-25 session is where new cases will be heard. So we had 3 cases out of Illinois challenging the Illinois semi-auto and magazine capacity ban that had asked the Supreme Court to grant cert and review them. We had the range case, which it's a prohibited person case, I believe. Oh, that's a nonviolent felon who had some kind of welfare violation for, $1,000 or some very, very minor type of felony conviction, and he challenged his. He wanted to have the court say that you can't ban someone just because they're a nonviolent felon. And that case was up for review. And then there was the Antonyuk case out of New York, where the state is trying to invalidate CCWs in as many places as possible by declaring many places to be sensitive places where guns can be entirely banned, even if you do have a permit to carry in public. Okay, so those were the basic cases. There were also a number of individuals who had challenged their ban on firearms possession for some kind of a felony conviction or cannabis or whatever it was. There's a bunch of individuals. Those were not very high profile cases. So today the Supreme Court denied, I'll start with the Illinois cases, they denied cert in the Illinois cases. Now, that's not particularly unusual because those cases were up on an interlocutory appeal. That means there was no final judgment in the lower court. Remember, when you file a lawsuit in court, you seek a preliminary injunction, you either win or you lose, and that can go up even before you move on with the case in the trial court. Ultimately, the end of a case is a judgment. So there was no judgment in any of those Illinois cases because the Seventh Circuit just said, you're not likely to prevail. We're going to invalidate this preliminary injunction that the trial court had granted, and then we're going to send it back down to the trial court. And the Illinois cases are all in the trial court in front of Judge McGlynn in Southern District of Illinois right now, and they're going to trial in September. So he's rushing those cases along, and there will be a judgment. Now, the state will probably lose again, and then the Seventh Circuit will rule again, now on the judgment. And then depending on how they do that, that will go in front. We will be asked if we lose in the Seventh Circuit, which if we have the same judges, we probably will, no matter how right we are. Then that will go to the Supreme Court again. And significantly, Justice Alito and Justice Thomas both issued a statement along with the denial of cert that said the Seventh Circuit got this decision wrong. And once you get a judgment, come on back and we're going to look at this again. So that's all. That case is still very much alive. We have to we have to fight all the battles to get to that judgment and then take that to the Supreme Court, where there's a very good chance that they will grant cert now because they're telegraphing that they want to see this case when the judgment has been entered rather than now based on the preliminary injunction, the interlocutory appeal. So that's what's happened in the Illinois cases. In the range case, that's a prohibited person case, and the court said, in light of Rahimi, we're going to GVR this case. Remember, so that's the other thing the Supreme Court can do. They can grant cert, but rather than having all the arguments and briefs filed, they can simply say, we are vacating the lower court's judgment and remanding this case for further consideration by the lower court in light of our recent decision in this case, in Rahimi. So that's what they did in both the Range case and the Antonyuk case. They GVR'd, granted cert, vacated the lower court decision, and remanded the case back down to the lower court for further consideration in light of Rahimi. Now, that's a good sign because they don't vacate lower court decisions when the lower court decision is right. So by vacating those lower court decisions and sending it back down, they're telling those lower courts to look what we just said in Rahimi and apply those to these cases. Now, in the Range case, in the Rahimi case, they said a violent, dangerous individual who has had due process and been determined to be a violent, dangerous individual can be disarmed, at least temporarily. That's all it said. In the Range case, there is no violence, there is no restraining order, there is no due process, there's nothing that would indicate that he's dangerous. And so all of the things that the Rahimi case decided now should work to his benefit when he goes back to the lower court. Because that's a prohibited person's case, and the Rahimi case was a prohibited person's case. Now, in Antonyuk out of New York, you have a prohibited places case. So this is where, even with a CCW, even with a license to carry in public, you can't carry because the place is deemed to be sensitive. Now, Rahimi was not a sensitive places case, so it's a little less instructive to the New York federal court. But nonetheless, it reiterated Bruen, it reiterated Heller, it laid out the steps that have to be taken, and it should. I mean, as I said, the Supreme Court does not vacate lower court decisions that are right. So we will have to be litigating, and CRPA and Second Amendment Law Center will be very much involved in litigating what the Rahimi case means for states that want to over-designate areas as sensitive.
I mean, at the very least, this all sounds promising. It sounds like the side of the Second Amendment is going to win in the end of the litigative process. I want to draw it back to California, though. We've had some lawsuits here in California in federal district courts in the Ninth Circuit that became kind of stagnant because we were waiting for some indications of the Supreme Court. I guess my question to you is, do you think that those indications have come to fruition to the point where, and I mean, there has been some movement in the courts. It's not like everything has come to a stop, but some of the bigger cases like the Duncan case, the Rhodey case, do we have enough from the Supreme Court here for those lawsuits to continue moving forward?
They'll keep moving forward. The question is, did whatever the Supreme Court said in Rahimi help us or not? And I think it helped us because it reiterated Bruen and Heller, but it hurt us in the sense that the Supreme Court accepted two historical analog laws as justification for disarming a dangerous individual, at least temporarily, under a modern day law. But the Rahimi decision is very narrow, very limited, and very it doesn't really apply to most of the case, to any of the cases that are going on in California, Duncan or Rhodey or Boland or any of the others. So the state already filed a letter saying, oh, look, Rahimi says this, so we should win. And we're submitted a letter that says they're full of baloney. And so we're going to have to litigate that. But Duncan is, again, now pretty much at the head of the line for a decision. It's been argued en banc, and we're waiting for a ruling. The most important question in Duncan, and the question that Justice Thomas and Justice Alito pointed out in their statement that went along with the denial of cert in the Illinois cases, was that the Supreme Court has not really defined what a bearable arm is, and it needs to. Even though we think it's intuitive, it's a small arm that may or may not have military application. It's not, a grenade or something like that, probably not. But a bearable arm does include a fully automatic. That's not to say they can't be regulated, but that's part of the second step of the second question, which is whether or not there's a historical analog. But I think that the Ninth Circuit is going to try and take advantage of this and say, well, magazines aren't arms, even though there's plenty of contrary authority that says that, they're an integral part of the firearm. If you can ban a magazine, why can't you ban a barrel or a trigger or any other integral part of a firearm? So that's the debate we've had in Duncan, and we'll see what the Ninth Circuit does with that. But if they go so far as to say that a magazine is not an arm that's covered by the right to keep and bear arms in the Second Amendment, then that's almost certainly going to be accepted by the Supreme Court, so that they can clarify what is a arm that the Second Amendment protects.
Well, certainly a lot to look forward to with Ninth Circuit and California Second Amendment litigation. A lot to be curious about on how these federal government and state government agencies are going to operate now that they can't interpret for their own these ambiguous laws. I guess I'm just sort of curious, what are your final thoughts on the way that this is going to shape the nation with Second Amendment rules and regulations?
Keep one thing in mind. I don't believe that the Loper-Bright decision restricts state. It was tied to the Federal Administrative Procedures Act, and to the extent that the Federal Administrative Procedures Act is different from the California Administrative Procedures Act, state agencies may still get away with their shenanigans. And Cal DOJ is famous for misinterpreting and interpreting regulations in the way that gives them more power. The California Department of Justice Firearms Division, they're famous for that. So we'll see how that plays out. But beyond that, folks, just keep in mind that that we are fighting. CRPA and our strategic partners are fighting in every venue, in every court, and even in other states where the precedent might affect us here in California. And we are CRPA has great deals with the lawyers that represent it, but it still takes money because it takes time. And so whatever you can do to support CRPA, whatever you can help contribute, and also get involved in the CRPA chapters so we can sway some elections, because there's only some of these local elections are decided by 100 votes or less. So get involved, donate if you can, stay informed at least, subscribe to the CRPA newsletter at crpa.org, and keep your brain in the game, and we'll keep fighting it for you.
Absolutely. Well, Chuck, I know you're a busy guy. You got a lot going on. I want to thank you very much for coming on and spending some time with us.
Always a pleasure, Kevin. Thanks for having me.
Absolutely. And guys, if you want to see more videos, more breakdowns on Second Amendment litigation and legislative efforts, please, once again, be sure to like, share, and subscribe to these videos. Make sure and hit that little notification bell so that as we come out with these videos, you get them instantaneously in your feed. Thanks, guys, and we'll see you on the next one.